Foreword. I want to thank everyone who responded to the government's Human Rights Act reform, a modern Bill of Rights consultation. Your input has informed our approach on introducing a UK-wide Bill of Rights to replace the Human Rights Act. The UK has a long and proud history of liberty and individual rights. It stretches back to the seminal Magna Carta, signed by King John in 1215, and the Bill of Rights and Claim of Right in 1689, which set out many of the basic civil liberties we enjoy today. That history continues right through to more modern laws designed to protect individual rights, such as the Disability Discrimination Act 1995. The Human Rights Act was introduced in 1998. Despite its serious flaws, it has played its own part in the development of rights in our country over almost a quarter of a century. In fact, one of the great strengths of the UK's constitution is its ability to evolve to meet the needs of our society. Now is the time to take a fresh look at our human rights framework. This consultation was very much about tackling the flaws we identified with how the Human Rights Act was working in practice. It dealt with the broad relationship between UK courts and Parliament, as well as the European Court of Human Rights, alongside specific problems like the deportation of foreign national offenders. As I set out when I launched the consultation, we intend to remain a state party to the European Convention on Human Rights. Our proposals for the Bill of Rights focus on creating a domestic framework that strikes the proper balance of rights and responsibilities, individual liberty and the public interest, judicial interpretation, and respect for the authority of elected lawmakers. The Bill of Rights will emphasise quintessentially UK rights, such as freedom of speech, which underpins robust debate in a mature and modern democracy like ours. It will reflect trial by jury as a particular common law element of the right to a fair trial. We'll also provide a much clearer demarcation of the separation of powers between the courts and Parliament. Equally, we want to make sure that our human rights laws are better protected from abuse. We will therefore put public protection at the heart of human rights laws, and establish a framework to enable our immigration laws to prevent serious foreign national offenders from using certain rights, particularly the right to family life, to frustrate the public interest in their removal. Finally, we will introduce a permission stage, so that judges can sift out the most trivial claims before they waste more court time and taxpayers' money. People from all 4 nations of the UK have responded to the consultation. I look forward to working with colleagues across the country and the political spectrum to create a Bill of Rights that not only works for each of the 4 nations of our union, but also reflects and respects our diverse legal traditions. This consultation has been an important step in nurturing the UK's proud tradition of liberty and rights. It will allow us to introduce a bill that reinforces our quintessentially UK tradition of liberty, curtail abuses of the system to make our streets safer, restore public confidence in human rights, reinforce the independence of our world-class judiciary, and strengthen the separation of powers to safeguard the prerogatives of elected lawmakers in Parliament. Right Honourable Dominic Raab, MP. Deputy Prime Minister, Lord Chancellor and Justice Secretary.